Well, thanks very much, Tony, and thank you, Matthew, for your welcome to country. And can I thank Matthew Keogh and the Society for the honour they've done me in inviting me to present this year's Sir Ronald Wilson Lecture. Can I acknowledge, without going into the detail that Tony did, members of the Judiciary and other distinguished guests, including the two deans of the law school at Murdoch, our sponsor tonight, and at UWA. Can I make a particular reference to my colleagues from Lavin Legal, which decades ago, when I was a practising article clerk and then lawyer, was Lavin and Walsh. And as a member of the firm of Lavin and Walsh, I was one of the two article clerk members of the Law Society Council. So I stamped the beginning of my lecture with my Law Society credentials. The fact that I went off and did other things for 3 or more decades is entirely neither here nor there. I have prepared a formal paper. I'm under very strict instructions from Dean that I have to go for 40 to 45 minutes, so I've got my trusty timer on me. I won't read all of my paper, that would be over and above, but I will certainly give you the major thematics from the paper, and the paper will be there particularly for our Year 11 and Year 12 Law and Politics students to use as a resource document if they so choose. But can I thank again Tony for his introduction. Tony's 2007 biography of Sir Ronald Wilson is the reference point for those seeking to both know and understand more of one of Western Australia's great jurists. I think Sir Ronald will be pleased if the first two source documents for any study on him were Tony's book and his own national inquiry into the separation of Aboriginal and Torres Strait Islander children and their families, the so-called Bringing Them Home report. The report, prepared on inquiry by the Human Rights and Equal Opportunity Commission with Ronald Wilson as its president, formed the basis for the Parliamentary apology to Australia's Indigenous peoples in February 2008, something I remain privileged to have taken part in as the then member for Perth. This year's lecture occurs on the 800th anniversary of the Magna Carta, an event of great significance, not just to lawyers, but to nations. The Society has marked this iconic event throughout the year, including through the subject matter of this evening's lecture, namely the protection of human rights of Australians. Ronald Wilson had a keen interest in the human rights of Australians. Some, as Tony points out in his book, believed through critical eyes that it was an interest acquired only late in life, having started off in the law as a highly forensic and diligent prosecutor. On the 15th of June this year, 800 years on to the day, British Prime Minister David Cameron said at Runnymede, and I quote, "We talk about the law of the land, and this is the very land where that law and the rights which flow from it took root. The limits of executive power, guaranteed access to justice, belief that there should be something called the rule of law, that there shouldn't be imprisonment without trial. Magna Carta introduced the idea that we should write these things down and live by them." On the same day, the Society's president, Matthew Keogh, published, and I quote, "Today, these rights seem so basic and fundamental. It feels inconceivable that they would be removed or limited. An essential part of what makes Australia such a great place to live, work, play and invest is the fact that our society is safe, law-abiding and legally stable." The Society's president then warns of the dangers of complacency and the need to be vigilant about the protection of these rights, along with which, he rightly says, comes responsibilities. The topic of this evening's lecture, protecting the human rights of Australians through anti-terrorist laws and their enforcement, deals both with rights and responsibilities. You could be forgiven for thinking that in the 800th year of the Magna Carta, a more predicted or predictable topic might have been one which posited the need to ensure that counterterrorism or anti-terrorism measures did not in any way detract from the human rights of Australia. But I come from the viewpoint of international efforts and our own domestic legislative and executive efforts to protect the human rights of Australians from terrorism. I confess both author's licence in tweaking the general suggestion made to me by the Society and also that this evening's particular topic comes from the experience of spending the last 6 years of my time in the Australian Parliament as a member of the National Security Committee of the Cabinet. Both David Cameron and Matthew Keogh, and I suspect hundreds of others on the day, referred to living by the principles and the rights laid down by the Magna Carta. One cannot, of course, enjoy these rights in the modern day if one's life has been arbitrarily taken away by terrorist act. My thematic starting point for this evening's lecture is the Universal Declaration of Human Rights, adopted by the United Nations General Assembly in December 1948, Article 3. Everyone has the right to liberty, life and security of person. This is echoed by Article 6 of the International Covenant on Civil and Political Rights, the ICCPR, adopted by the General Assembly in December 1966 and coming into force in March 1976, namely, and I quote, "Every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life." Without in any way diminishing the importance of any other right contained in the International Covenant, but on the contrary, reinforcing their importance, their quiet enjoyment is rendered otiose by an act of terrorism arbitrarily depriving an individual of the inherent right to life as set out in Article 6 of the Convention. Australia agreed to be bound by the Convention in 1980 and subsequently its 2 optional protocols, including the second optional protocol relating to the elimination of the death penalty. In the 7th edition of his text, International Law, Malcolm Shaw says, and I quote, "The rise of international terrorism has posited new challenges, as states and international organisations struggle to deal with the phenomenon while retaining respect for the sovereignty of states and respect for human rights." While we find earlier reference to international terrorism in United Nations General Assembly resolutions, in particular the 1994 Declaration on Measures to Eliminate International Terrorism, it is only in the immediate and subsequent aftermath of the terrorist attacks on the World Trade Center in New York on September 11, 2001, that we see, as Evans puts it, an evolving state practice with respect to international terrorism. This includes Security Council Resolutions 1368 and 1373, both calling on all member states to take necessary steps to prevent the commission of terrorist acts. Resolution 1373 declares international terrorism to be a threat to peace and security, which Resolution 1368 declares authorises the inherent right of individual and collective self-defence, previously generally believed to apply to states or state-sponsored actors, not to a threat from or in response to non-state actors. We now find, in addition to the 2006 General Assembly resolution establishing the United Nations Counterterrorism Strategy, 18 United Nations conventions condemning and dealing with international terrorism in its various manifestations, such as hostage-taking, hijacking and bombings. The general approach of these conventions is to identify the terrorist conduct, condemn it, and call upon member states to take action against the conduct, including by making it a domestic offence within their own jurisdictions. The events of September 11 crystallised national security as a global and domestic issue of our time. These events, whether we like it or not, and most of us don't like it, were a fundamental shift, a so-called game changer, but where the price of the game was peace and security for nations and the quiet enjoyment of right to life for innocent individual citizens. This threat is not something which international law and international institutions have been accustomed to focus on, namely one state against another state, but zealous and extreme non-state actors who are quite prepared to die themselves as part of their modus operandi, which as a consequence requires a different strategic and tactical response from states to protect their citizens. September 11 caused us then and since to ask a range of questions. What is the evolving threat that we are trying to deal with, both in our own domestic jurisdiction and offshore with our international partners? What are our international counter-terrorism obligations? How are our human rights protected in Australia? What adverse impact can anti-terrorism laws have on human rights? And is this impact reasonable, indeed necessary, in the modern era to stare down a greater evil? where the risk is to the inherent right to life? What is the required evolution of our domestic anti-terrorism laws in response to an ever-changing threat, particularly in a world of mass digital communication? What principles should guide the development of anti-terrorism laws? What should the oversight and review of Australia's counter-terrorism laws be? What role does the Parliament and the judiciary have in this oversight and review? Should there be a charter or bill of human rights to ensure a proper balance between anti-terrorism efforts and the protection of human rights? Or is this better sustained by more historically familiar Australian legislative measures? How are governments held to account for their response to this threat, including their advice to the public about the state of the threat? This evening it will not be possible to deal exhaustively or in detail with all aspects of these and many other relevant questions, but let me seek to deal with some of them. Since September 11, the Australian community has been resilient in responding to terrorist attacks, which have occurred and cost Australian lives both here and overseas. We have a challenge to protect and promote our open, democratic, tolerant way of life while tackling this threat to life. With their cooperation and support, our national security agencies have been able to thwart a number of potential attacks in Australia overseas. Their role is vital, and the way in which we want them to do it, lawfully, effectively, and consistent with our national values and virtues, is also vital. It must continue to be regarded as such by the Australian people. Last year, in light of global developments, particularly in Syria and Iraq, the threat of homegrown extremism, lone wolves and returning fighters, the Australian government raised our national threat level to high, namely, an attack is assessed as likely. The conflict in Syria and Iraq is a new, evolving dimension in the terrorist threat for Australians. More than 120 Australians are reported to be fighting in Syria and Iraq. A number of these individuals have been fighting with jihadist groups such as Jabhat al-Nusra and Daesh. If able to return to Australia, these fighters could bring to Australia new military skills and connections to and with international jihadists. We are now also seeing a new dimension in active recruitment and radicalisation campaigns targeting Australia and Australians, and using social media, the preferred medium of choice of our youth, to do so. The Minister for Justice, Michael Keenan MP, said at the Lowy Institute last month that 160 Australians are actively supporting extremist groups through financing and recruitment. ASIO is currently investigating 400 high-profile cases, double that of a year ago. The government has cancelled 120 passports and refused 16 for those wanting to join terrorist groups overseas. The Foreign Minister has suspended a dozen passports under foreign fighters legislation introduced last year. The Lowy Institute has previously observed that, and I quote, "In the last decade, real progress has been made in diminishing the terrorist threat by reducing the number, connections and lethal skills of the international pool of jihadists that emerged in the period leading to September 11. Unfortunately, as the Institute itself warns, current developments in the Middle East are rapidly refilling that pool. It may end up considerably larger than the one that existed in the decade post-September 11, and it is unfortunately a pool that is likely to have a not insignificant number of Australians in it." So what are some of the facts to date about the scale and threat and the use of legal powers to counter it in Australia? The review of counter-terrorism machinery established by the Department of Prime Minister and Cabinet in January this year show that there have been 35 prosecutions and 26 convictions related to terrorism in Australia in the post-2011 to 2001 period, the September 11 period. The review reminds us, thankfully, and I quote, "There have been no large-scale terrorist attacks on Australian soil in this period. The two terrorist attacks that have occurred domestically, the Martin Place siege in December 2014 and the stabbing of two policemen in Melbourne in September 2014, were carried out by individuals who planned and acted alone. Crimes planned like this are by nature always extremely difficult for police and security agencies to prevent." In light of these developments and the spectre that will be ongoing for the foreseeable future, in my view, Australia's anti-terrorism laws and their enforcement must continue to respond to an evolving and serious threat in a manner which protects Australia and Australians, and to do this in a country and with a people whose identity, values and cultural heritage are inextricably interwoven with safeguarding rights and safeguarding freedoms. There is an important philosophical, legal and practical tension here that we cannot afford to lose sight of, and this is central to my thematic this evening. On the one hand, the United Nations Counterterrorism Strategy reaffirms the respect for human rights and the rule of law as the fundamental basis for the fight against terrorism. In supporting this strategy, Member States recognise that effective counterterrorism measures and the protection of human rights are not conflicting goals, but complementary and mutually reinforcing. When linked to the inherent right to life, it is, in my view, axiomatic that there is an obligation on the part of a state to further the protection of the human rights of its citizens by necessary and effective counterterrorism measures. But it is not necessarily easy or straightforward to ensure that these are, quote, complementary and mutually reinforcing, as the counterterrorism strategy says. So how do we develop an effective and evolving counterterrorism framework that is complementary with safeguarding human rights? That is challenging, and not the least because there are tensions in our efforts to deliver on key human rights as goals in and of themselves. There are tensions between freedom of speech and non-discrimination or incitement to racial hatred, tension between efforts to protect the inherent right to life and individual liberty itself. Indeed, the Australian Independent National Security Monitor report of November 2013 commented that there is a, quote, perennial challenge in seeking to reconcile, quote, the public interest in the proper administration of justice and the public interest in national security. Getting the counterterrorism legal framework right here in Australia, or indeed elsewhere, is only part of the challenge, albeit a critical one. Getting our laws right in legislative terms then requires them to be implemented and enforced effectively. Authorities across our federated system and the community must work together to counter violent extremism and to safeguard and promote our recognised rights and freedoms. This is a global challenge for the international community, and our domestic efforts must as well align with our international efforts, including an Australian contribution to the development of sound, effective international norms, laws and state practice. The effort required is resource intensive, and our capability must move with the evolving threat. Government is rightly asked to account for its decision in this regard. The legislative framework, policies and resource allocation involve an appraisal not just about the threat, but the importance of a proportionate tackling of the threat of terrorism. There is a debate about the scale of the threat and whether government attention and resourcing is proportionate. There is a question about whether we accept the ongoing threat as a justification for specially tailored laws and policies, and how long these laws should endure with or without sunset clauses. Some have described the threat of ISIL as an existential one, or as the largest threat since communist and totalitarian regimes in the last century. Others point out that other conduct may in fact currently involve greater casualties and greater fatalities here in Australia, and suffer from considerably less attention or resourcing. The scourge of domestic violence is but one example. So there are no easy answers, but as a former member of the National Security Committee, I regard national security as a primary and principal responsibility of government. But I also come from a tradition of supporting more equitable social policies and outcomes and tackling adversity, including that caused by gender-based violence and discrimination. Determining whether resourcing is proportionate, whether laws are developed in a measured way, ensuring laws and their enforcement are not allowed to overreach based on claims of extraordinary circumstances, are difficult appraisals to make and ones which need to be constantly revised and continually assessed. Security and law enforcement agencies need to be appropriately resourced. In Australia, we have seen the budgets for our security agents grow since September 11, 2001. The seriousness of the threat and the need to grow the capability of relevant agencies to respond has meant important decisions to provide new resources. According to the January 2011 review of Australia's counterterrorism machinery, from the financial year 2001-2 to the financial year 2013-14, ASIO's budget increased fivefold, ONA's budget quadrupled, the Office of National Assessment, ASIS's budget more than tripled, our overseas intelligence agency, and the Australian Federal Police Force's budget more than doubled. Allocation of these resources and more seek to deliver on a fundamental responsibility of a national government, namely to protect and defend the national security interests of the Commonwealth of Australia and the personal security of its citizens, and to do all of that consistent with the values and liberties of a free, tolerant and democratic society. Having said that, there will, in my view, be one overriding public expectation. The Australian public expects the government of the day and its various agencies to protect Australian citizens, including from terrorist attacks. And if in the terrible circumstances that there is such an attack and loss of life, after the provision of comfort and support to the families of those killed or wounded in such an attack, there is only one question that will be asked. How could those in authority and responsibility have allowed such an attack to occur? This is the question that has and will override all others, and the one human right at the forefront of it all will be the inherent right to life of the innocent victims. Or to put that public expectation at an earlier preventative point in the cycle, when Parliament legislates for anti-terrorism and subsequently provides law enforcement and security agents with the resources to implement them, I suspect that while there will be a public expectation to be respectful of human rights, their principles and their protection, the preservation of life will be seen as the overriding imperative. In the wake of Martin Place, we asked ourselves, how did this occur? Could or should it have been prevented? Were there indicators that could have legally been acted upon? Does anyone in authority need to be held to account? And what can we do in future to prevent similar occurrences? A review of the Martin Place siege has just been released, throwing a spotlight on the complexities of that challenge, and I'll refer to that in more detail later. Since September 11, successive Australian governments have introduced more than 60 laws relating to counter-terrorism. These include new criminal offences, detention and questioning powers by authorities, anti-terrorist financing, interception powers, the ability to control people's movement and activities by order without criminal conviction, passport cancellation, intelligence gathering and information sharing, the ability to prescribe terrorist organisations and more. And as outlined above, our security and law enforcement agencies have grown in resourcing and capability to implement these laws. In 2008, the Australian Human Rights Commission said, and I quote, "Counterterrorism laws can have a profound impact on fundamental human rights and freedoms, including a right to fair trial, the right to freedom from arbitrary detention and arrest, the right not to be subject to torture, the right to privacy, the right to freedom of association and expression, the right to non-discrimination, the right to an effective remedy for a breach of human rights. These are all rights protected under international human rights treaties, including the International Covenant on Civil and Political Rights and the Convention Against Torture and Cruel, Inhumane and Degrading Treatment or Punishment. Australia has ratified both of these conventions. At the same time, the Australian Human Rights Commission said, and I quote, "Making sure counter-terrorism measures comply with Australia's human rights obligations involves correctly identifying which human rights are non-negotiable and which can legitimately be restricted in certain circumstances. This is because international law allows certain derogable rights to be restricted, but only if the restrictive measure is a necessary and proportionate way of achieving a legitimate purpose." Article 4.2 of the International Convention on Civil and Political Rights says, for example, that the following rights are non-derogable: the inherent right to life, freedom of thought, conscience and religion, freedom from torture or cruel, inhumane or degrading punishment or treatment, and elements of the right to fair trial. Derogable human rights in international law can be limited in certain conditions: a state of public emergency, or if the limitation is proportionate and necessary response to a threat to national security. In short, a proportionality test applies. We ask ourselves, why is the action necessary? To what extent does the action impair the right? Could the purpose of the action be achieved through less restrictive measures? And do legal safeguards against abuse exist? Our rights in Australia go beyond Australia's international human rights commitments. There are also common law rights that could be relevant in the broader consideration of anti-terrorism laws, and the Australian Law Reform Commission has a review of those common law rights and privileges currently under consideration. The results of that review and report, I'm sure, will add to the heart of the discussion. In my paper, I then go through the range of international and domestic measures from international conventions, Commonwealth statutes and Security Council resolutions, which outline what nation states or member states and Australia have done in this area over a considerable period of time. But I would be testing my luck and your patience if I detailed them for you, but they are available in the published paper. Australia's counterterrorism laws focus on terrorist act offences, terrorist organisations, prevention of the financing of terrorism, urging violence and advocating terrorism offences, and foreign incursion and recruitment offences. Australia's first counter-terrorism specific laws were introduced in 2002 and created a range of terrorist offences in Part 5.3 of the Schedule to the Criminal Code Act 1995 of the Commonwealth, which included engaging in, preparing, planning or training for terrorist acts and offences relating to terrorist organisations. These have been amended significantly over the years, including to modify or add offences, create powers to investigate offences, and to enable authorities to help protect the public from a terrorist attack. For example, in 2005, following the London bombing, provisions were introduced to enable police to obtain control orders and preventative detention orders. Last year, in response to the evolving threat I've outlined above, a number of legislative changes were introduced to strengthen the ability of law enforcement, security and intelligence agencies to prevent and disrupt Australians from travelling to fight with terrorist groups overseas, and to address the threat of returning fighters with the will and capacity to conduct attack upon return, to introduce an offence for advocating terrorism, and to enter a declared area without a legitimate purpose, and lowered the threshold for a control order. States and territories also have counter-terrorism specific legislation as part of a national framework. States and territories have prevention detention order legislation which the Commonwealth could not enact for constitutional reasons, allowing detention of up to 14 days. The Commonwealth can only detain someone under a preventative detention order for a maximum of 48 hours. Any domestic law must obviously be constitutional and consistent with our international obligations. The principles articulated by a COAG review in 2009 remain relevant today. In 2005, COAG considered the evolving security environment in Australia in the context of the terrorist attacks in London in July 2005 and agreed there was a clear case for strengthening Australia's counter-terrorism laws. COAG leaders agreed that any new laws must be necessary, effective against terrorism, and contain appropriate safeguards. That is, we need to ask ourselves whether existing and proposed anti-terrorism laws are necessary and proportionate, are effective against terrorism, that is, they provide law enforcement, intelligence and security agencies with adequate tools to prevent, detect and respond to acts of terrorism, are being exercised in a way that is evidence-based, intelligence-led and proportionate, and includes safeguards against abuse. It is essential, in my view, to review our laws regularly to make sure that these assessments remain current and that powers are not allowed to continue if they are no longer relevant, effective, appropriate or necessary. Oversight, accountability and redress mechanism, the importance of setting appropriate sunset clauses on certain legal powers, timely and regular reviews to take account of new developments, incidents and the evolving threat levels are all important and necessary requirements in this regard. Australia has some strong oversight and review mechanisms in this area, and these should be safeguarded. Our oversight and review mechanisms or authority include federal, state and territory parliaments, ministerial oversight, including COAG, the Parliamentary Joint Committee on Intelligence and Security, the Inspector General of Intelligence and Security, the Independent National Security Legislation Monitor, the Independent Reviewer of Adverse Security Assessments, National Security Agency's inbuilt review mechanisms, the role of the judiciary and judicial review, and the role of a diverse and free press. Australia has also subjected itself to important internal-external reviews of our counter-terrorism framework, which have had an important influence on their ongoing development and amendment. Australia has had, for example, the 2005 COAG review of counter-terrorism legislation, the 2006 UN Special Rapporteur report, the 2007 report of the inquiry into the terrorist organisation listing provision of the Criminal Code Act 1995 of the Commonwealth, the 2008 report of the inquiry into the case of Dr Mohammed Hanif, Independent National Security Legislation Monitor annual report since 2011, and most recently the 2015 Martin Place Joint Commonwealth and New South Wales review. These reviews have also played an important role in shaping our debate and making sure we do not lose sight of the complex challenge of safeguarding human rights when tackling threat. There has been strong criticisms of Australia's counter-terrorism laws, including in the light of recent introduction of additional laws by the current government into this Parliament. The UN Special Rapporteur in 2006 made some criticisms of Australia's laws, pointing to, in its view, inadequate safeguards and redress. Earlier this year, Kent Roach, Professor of Law at the University of Toronto, was widely reported as describing Australia's, quote, hyper-legislation as having gone beyond that of Britain, America and Canada. Some have suggested the extent of Australia's legal framework will impact personal freedoms more than similar laws in such countries that may face a more significant terrorist threat than Australia does. Australia's laws have of course been subject to legislative review and parliamentary amendment. The previous federal government, of which I was a member, initiated some key changes in this regard. It established the Parliamentary Joint Standing Committee on Human Rights to examine and make statements of compatibility of new bills with human rights laws. It introduced the Independent National Security Legislation Monitor Act 2010 and appointed Brett Walker SC as its first monitor. The monitor has scrutinised and reported on key elements of anti-terrorism laws since its inception. The monitor continues despite the parliamentary efforts of a minority to repeal the Act. The Human Rights Parliamentary Scrutiny Act 2011 came into effect in January 2012. The Parliamentary Joint Standing Committee now reviews legislation for consistency with human rights obligations and requires a statement of compatibility to be prepared in respect of all bills introduced into the Parliament in relation to our commitments arising as a result of our international human rights conventions. As I mentioned earlier, the current government has enacted 4 tranches of legislation to strengthen the ability of intelligence and law enforcement agencies to investigate, monitor, arrest and prosecute homegrown terrorists, homegrown extremists and returning foreign fighters. The development of these laws and their passage through Parliament has been the subject of wide public debate and commentary. It is essential in my view to note here that the government was not giving a blank cheque to enact these provisions in legislation. The legislation was developed through various agencies of government and subjected to the rigours of policy development. It was then subject to the parliamentary scrutiny process and debate. There was referral for detailed consideration to the parliamentary committee system, which is open to public and stakeholder submission and involved careful assessment of the key principles I have outlined earlier. There are a range of proposed amendments by stakeholders and the opposition to improve oversight provisions, shorten sunset clauses for review and other important elements. This process goes to the heart of parliamentary scrutiny and the check and balance of getting an appropriate and proportionate outcome. Let me quote from the second reading speech of the Honourable Mark Dreyfus, MP QC, the Shadow Attorney General, on the Foreign Fighters Bill 2014, and I quote, "Our bipartisan assistance to the government on matters of national security is never a blank cheque. Bipartisanship on national security means that we share the government's assessment of the current threat and that we will support necessary and effective measures to address the threat. That means we conduct our side of the debate and our negotiations with the government in a constructive fashion. It does not mean that we will support every measure the government proposes. It does not mean that we will not advocate for improvements to those measures that we support to ensure that they will be effective. Mr Dreyfus also said that the opposition had worked hard to achieve Parliamentary Committee support for 36 substantial recommendations for improvements to this bill, some of which originated with suggestions arising from the COAG review and the Independent National Security Legislation Monitor, particularly in relation to improving human rights protection. Given the recent publication of the Joint Commonwealth New South Wales Martin Place Review, it would be inappropriate to have a discussion of the application of Australia's counter-terrorism laws and human rights without reflecting on that recent important review and what lessons this can provide in thinking about our laws and their effectiveness. What is noticeable very clearly in reading the review is that the questions of proportionality and effectiveness and the consideration of Australia's democratic rights and freedoms are central to its examination. This is as it should be. The review found that the judgments made by government agencies were reasonable and that the information that should have been available to decision makers was available. It said that any further controls would be based on judgments as to whether increases in policing, surveillance and controls and the related extra burden on the taxpayer and intrusion into Australian lives would make us appreciably safer. It concluded that the review's recommendations would maintain broadly the current balance in our existing regulatory and legislative framework. It said that the review's decision to not propose steps beyond this was based on the view that introducing substantial further controls involved a larger choice about the sort of society we wish to live in and is properly the province of the public and elected representatives. The review does throw a spotlight on the long debate about the appropriateness and efficacy of the control orders and preventative detention orders in Australia. Let me reflect on this for a moment. The review found that while Monis was consistently on the radar of law enforcement and intelligence agencies from the time he arrived in Australia, based on information available, at no point prior to the siege could he have been successfully charged with a terrorism offence under the law. The review also found that control orders and preventative detention orders are extraordinary, and that Monis's actions never reached the threshold for these powers to be used prior to the siege. However, law enforcement agencies pursued his criminal behaviour, so that while the Joint Counterterrorism team investigating Monis did not charge him for a terrorism-related offence between 2007 and 2009, it did pursue criminal charges against him for his use of a postal service to send offensive letters to the families of Australian soldiers killed in Afghanistan. Ultimately, Monis was convicted of these offences. The review found no evidence that counter-terrorism legislative powers could have been better used by law enforcement agencies. It did, however, have some suggestions, including and in particular in relation to bail arrangements and visa arrangements, which the New South Wales State and federal governments have started to consider and act upon. When the review examined the question of Australia's control and preventative detention orders, the review found that, and I quote, "The regime contains thresholds and safeguards to ensure the powers are proportionate and only used where appropriate. A key threshold is an identified risk to public safety and, in the case of preventative detention orders, an imminent terrorist threat. Whilst recent amendments have strengthened the control order and preventative detention order regimes, they have not departed from this fundamental principle. And while not triggered for Monis, this regime has been used before. To date, 4 control orders have been issued under Commonwealth legislation and 3 preventative detention orders have been issued under New South Wales legislation. The review also noted, and again I quote, that control orders and preventative detention orders were vital tools in assisting in the prevention of terrorist incidents. It is critical to the efficacy of these tools that they are constantly monitored in light of the evolving nature of the terrorist threat and operational experience. The review as well recommended that the Australian and New Zealand Counterterrorism Committee should monitor the operation of control orders as well as preventative detention orders to ensure they meet evolving operational needs. It is important to note that the review emphasised that the operational effectiveness of these tools needed to remain the priority. Of course, for each, ensuring adequate protections is also a requirement, but if they are to evolve to meet the changing threat environment, we must be nimble in how we ensure that operational effectiveness. I'm conscious that I've not touched in detail on the question of countering violent extremism and how to do this effectively. This is a live debate in Australia now as we consider how young people in their mid to early teens can be so quickly radicalised and attracted to the messages of Daesh or ISIL. There is, of course, consensus around the nation that prevention is better than cure. A lot of consideration and effort is going into developing community engagement programs. However, counter-radicalisation is notoriously complex and global examples of effective programs are few and far between. Much of the discussion at present is around the conditions and motivations for radicalisation, and again, there is no simple answer. The reasons are likely to be as multifaceted as the actions required to counter it. One thing is certain, we cannot shy away from having a discussion in our community, acknowledging the issue and coming together to deal with it. The terrorist threat is evolving and presenting new challenges to nations, including Australia. Anti-terrorism laws must strengthen, where necessary and appropriate, our ability to respond to an evolving and serious threat at home and abroad in a manner which protects Australia and Australians, a country and a people whose identity, values and cultural heritage are inextricably interwoven with safeguarding rights and freedoms. There's an important philosophical, legal and practical tension here that we cannot afford to lose sight of. The recent Martin Place review shines a spotlight on the effectiveness of some elements of our legal framework and also underlines the importance of ongoing review and oversight, the importance of testing the cost, effectiveness and balance of what we are doing to respond to this evolving threat. As a society, we need ongoing flexibility to ensure operational effectiveness against that threat. The threat is evolving and we have a tough job to stay ahead of it. Our framework must be nimble, but in the process, human rights protection must be required. And I believe there can be confidence that the system of oversight works well to ensure adequate safeguards. In the face of such threats, the reality is we need to be pragmatic and in particular circumstances see some rights as less important than others. But balance cannot be lost. That is the responsibility of government, for which it must both be accountable and subject to scrutiny, particularly given that it is government which has access to and knowledge of the assessment and the threat. The formation of successful, prosperous and safe communities, where the pursuit of individual rights and liberties is possible or a given, does require the sacrifice of some level of individual freedom, even if we define freedom only as the right to do as one pleases without reference to others. The Magna Carta recognised that, in a way, it both sets forth comprehensive rights and responsibilities at all levels of society to ensure that while the previous unchecked powers of the king were subject to limitations, it still provided for the administration of the common good and a well-regulated society, dependent, for example, on some level of taxation and a functional legal system. Since the Magna Carta, society has always been prepared to surrender some liberty for order and common protection. At its core, the Magna Carta was a blow against the concept that one person, indeed any one person, could treat others as less than themselves, as less than equal before the law, as less than human. That is where the trade-off between rights and responsibilities developed since 1215 come into play. It is primarily a duty of the state to protect its citizens from harm. This duty must be balanced against the rights of citizens to go about their activities with quiet enjoyment. It is, in my view, actually easier to see that where innocent victims are deprived of their inherent right to life, a core human value. In protecting our citizens, we must inevitably encroach on their rights. It has ever been thus. Magna Carta was perhaps the first attempt to codify and limit this process by acknowledging the need for a system of law. And finally, what would Ronald Wilson's view, perfect timing, and you can tell that the Defence Minister's phone hasn't changed from the sonar alarm on the time. And finally, what would Ronald Wilson's view have been on all of this? Perhaps it's the case that the combination of a highly committed forensic Crown prosecutor, criticised by some for being too zealous in that role, and the irrepressible human rights advocate he was later in life, might just have helped to provide the right balance to find in Australia's anti-terrorism laws and their enforcement, as against a terrorist threat to the inherent right to life and therefore human rights generally. Thank you for listening to me, and I again thank the Society for the honour of inviting me to deliver this year's Sir Ronald Wilson Lecture.